Hi, Vent. Thanks for making the time to join us today.
Hi, Matilda. It's great to be here.
So I'll just get right into the discussion. Just a couple of months ago, WIPO member states adopted by consensus a historic new treaty relating to intellectual property, genetic resources, and associated traditional knowledge. For someone who has little to no knowledge of what this means and what this stands for, what are the key things to note?
Okay, so let me give you a very simplified example of what this is all about. Let's imagine there's a company that has developed a new skin cream. And in making the new skin cream, it conducted research on a plant that is native to a particular country, Mexico, Australia, Botswana. And the new skin cream uses the benefits from the plant. So maybe it's fragrance or it's anti-aging benefits and so on. The company also, in finding out about the plant, talked to some of the local people, talked to an indigenous people from the country concerned. And they know about the plant because they've been the stewards of that plant for hundreds or thousands of years. Now, and again, I'm being very simple and simplifying the story. But normally, if the company then wants to apply for a patent for its new skin cream, it wouldn't normally need to talk about and disclose where the plant came from and who gave them the knowledge, because that information is not normally relevant for the patent examiner to work out if the invention is novel and inventive. Now, the main change in the new treaty is that moving forward, once the treaty comes into force, in the simple example I've used, the company, the cosmetics company, would need to disclose the country of origin or the source of the plant and the provider of the indigenous knowledge when it files for the patent application.
I see. So you've mentioned a patent disclosure requirement. What are some of the other main features of the treaty?
Yes, and I'm glad you asked that because it's important that the viewers look at the whole treaty. It's actually quite short. There's a preamble and 22 articles, so it's quite readable. But some of the other main points would be if the applicant genuinely doesn't know the country of origin or the source of the plant, in my example, or the indigenous knowledge, he can simply or they can simply say so. The Patent Office, which would receive the information, does not have an obligation to verify the authenticity of the information. The obligation doesn't come into effect retroactively. The scope and contents of the treaty will be reviewed 4 years after the treaty comes into force. And I think finally, the contracting parties to the treaty are invited, if they wish, to establish databases that their patent examiners can use when examining patents in this area.
And what are some of the other objectives of this treaty? I mean, I know it's the first treaty to address the interface, between these very important topics and also include provisions for indigenous people and local communities. What are the other main objectives to note?
So biopiracy is really what the treaty aims at. It's an informal term, but more formally, what the treaty's objectives are related to the patent system. So the first objective is to enhance the efficacy, transparency and quality of the patent system, efficacy, transparency and quality. And then secondly, to prevent the granting of erroneous patents. That's the biopiracy issue. Patents that are, in the example I gave, based on a plant but actually not really novel or inventive. And this has been a concern for many countries for several decades.
So what's the political significance of this treaty?
So the treaty is important practically, but politically and symbolically, it's a huge outcome, as we've touched already on the 25-year-long journey inside of WIPO. So points of view before the conference began, the final stage meeting began, were still quite wide apart. And so the fact that the member states managed in the 2 weeks of the final meeting to reach consensus and adopt a treaty by consensus is a huge outcome. The treaty sends important signals about the ability of the patent system to evolve in the interests of enhanced access, empowerment and inclusivity. It caps the 25-year journey, of course, and it also is an uplifting message about the benefits of the multilateral system. You've mentioned already the treaty is actually two firsts. Yeah. It gets two prizes for being first. The first is it's the first international treaty that reconciles the goals of promoting innovation, conserving biodiversity, and at the same time recognizing and respecting the rights of indigenous peoples. So it's the first treaty to show that these three goals are not incompatible. And the second first is it's the first international intellectual property treaty that refers explicitly to indigenous peoples.
I see. Thanks for noting that. I just want to go a bit to your role in the entire negotiation process. I mean, I know how UN negotiations can be, and in the face of, you know, geopolitical challenges and multilateralism being at risk and all that. What was your main role, and what was the most rewarding aspect of this entire journey?
So my team and I, and many members of the team, we've been together for many, many years. And so we know the issues very well, we know the politics, we know the people very well, which is important. So we played a key role in the final stage, of course. But a conference like this is a massive undertaking. And so it's really about teamwork across the whole Secretariat. Under the leadership of Director General Darren Tang, there was an enormously wonderful spirit within the whole organization. I've been here for many years, and it was unprecedented in my view, actually. I want to make a special, pay a special tribute to the president of the conference, Ambassador Guilherme Patriota from Brazil, who was immense. And from a more personal point of view, of course, for me, after all this time, it's a real privilege that I've been able to see something begin and also end. And it's not often that one has that opportunity in the work that we do. And I have this amazing team, and we are like a family now. And it's been an honor for me to be part of that.
That's really great. I can detect the passion in your voice. So now that the treaty has been adopted, what next? What are the next steps?
So the treaty is not yet in force. It's been adopted, but is not yet in force. And it's important it comes into force as quickly as possible, because then the practical benefits, we've talked about the symbolism of the treaty, but its practical implications also need to be felt. So the sooner the treaty comes into force, the more it becomes practically useful. And countries will begin to implement the treaty in their national laws or regional laws. And we'll begin to have experience with the treaty. Does it work? Does it meet its objectives? Do indigenous peoples benefit from it? Does it actually work? So the treaty will come into force when there have been 15 ratifications or accessions, and 3 months after that date. And so we're working as hard as we can to help countries who want to ratify or accede to it.
Well, that was a very nice segue to end our discussion. Thank you so much for making the time to join us today, Ben.
It's been a real pleasure.